Hi guys, welcome back to my channel. So today in this video I would like to read an article entitled Maritime Liens, Mortgages and Priorities. The substantive law applicable to maritime liens, ship mortgages and priorities differs significantly from the law that is applied to the land-based property, as does the procedural law. Mortgage registered vessels. The law applicable to mortgages of ship is dependent on whether the particular ship is a registered vessel under the Canada Shipping Act 2001. If the ship is registered vessel, sections 65 through 72 of the Canada Shipping Act 2001 apply. These provisions require that mortgages and transfer of mortgages be in the form prescribed and be registered in the Canadian Register of Vessels. Failure to register the mortgage can result in a loss of priority, as in British Columbia v. PT Care and Yacht Rental. The Act further provides that priorities as between mortgages is by order of registration unless all mortgages consent otherwise in writing. The first mortgagee of a registered vessel is empowered with the right to sell the vessel. A subsequent mortgagee may not sell the vessel without an order on the federal court or the consent of the prior mortgages. Finally, the Act provides that a registered mortgage is not affected by the bankruptcy of the owner, and the mortgage has priority over creditors in the trustee in bankruptcy. The form prescribed for a mortgage of a registered vessel is very brief, containing little more than the names of the parties and a space to enter the nature of the consideration and whether there is a collateral agreement. Due to the fact section 65 through 72 of the Canada Shipping Act 2001 provide relatively little regulation over ship mortgages, it is customary, if not universal, for there to be collateral agreement containing the full terms of the mortgage agreement. Such a collateral agreement will normally contain extensive terms including charging provisions, representations and warranties of the mortgagor, repayment terms, insurance requirements, and remedies on default. It is to be noted that the Personal Property Security Act of British Columbia, Nova Scotia, Prince Edward Island, Newfoundland, New Brunswick specifically exempt mortgages registered under the Canada Shipping Act from the applications of those acts. The Quebec Civil Code similarly exempts ships registered under the Canada Shipping Act. The laws of the other provinces are silent on the issue, which can present difficulties, as in Royal Bank. Unregistered vessels. With respect to unregistered vessels, there are no federal statutory provisions similar to sections 65 through 72 of the Canada Shipping Act 2001. Such vessels are subject to the provisions of the Provincial Personal Property Security Act, which do not exempt unregistered vessels. However, there may be constitutional issue as to whether the Provincial Personal Property Security Act can validly regulate mortgages on registered or unregistered vessels. This is particularly so when addressing priorities between the mortgages and maritime liens, where the Provincial Act and Maritime Common Law can have different results. Nevertheless, many practitioners register such mortgages under the Provincial Act, which seems prudent. Types of lien. There are various liens recognized in maritime law. The categories are traditional maritime liens, possessory liens, and statutory liens. All can be and should be enforced by way of an action in rem, which means that proceedings should generally be commenced in the in the federal court as opposed to the provincial superior court, with the possible exceptions of the Supreme Court of British Columbia, which is the only superior court with rules providing for interim. Traditional maritime liens. A traditional maritime lien is lien unique to maritime law. It is a privileged claim over maritime property law. Accrues from the moment the claim arises. It travels with the ships unconditionally, even into the hands of bona fide purchaser for value whether with or without notice. This is defining characteristic. It is enforced as with other claims by means of an action in rem. The traditional maritime liens are claims for seamen's wages, salvage, collision damage, master disbursement, and bottomry. Traditional maritime liens have a priority ranking above mortgages. Possessory liens. The common law possessory lien is recognized under the Canadian maritime law. Such a lien requires continued uninterrupted possession or it lost. Possessory liens usually arise in the context of ships, repairs, and claim for freight. Such a lien have priority over mortgages and also over any subsequently accruing maritime liens. However, maritime liens that attach prior to the possessions of the possessory lien claimant have priority. Provincial statutes that provide for registrations of liens and the continuations of the lien after possession is given up, such as the Repairers Lien Act and Warehouseman Lien Act of British Columbia, have been held to apply to liens on ship. However, there is a constitutional issue as to whether such status can validly apply. Statutory liens. Statutory liens are liens created by a validly enacted statute. They have the priority given them by the statute that created them. There are many such liens, including claims by the master of crewing wages, which rank in priority all but marshal's cause and salvage claim. Claims by the master for disbursement, which rank in priority to all but wages claim, marshal cause, and salvage claim. Claims in respect fines or debt to the minister have a super priority ranking above marshal's expenses. Claims by carrier for any amounts due which must be perfected by notice and gives a right of sale. Claims by a port authority for amount owing which rank in priorities to all but claims for wages Canada Maritime Act, and claims in respect of goods, material, or service supplied to the foreign vessel, and claim arising out of a contract for the repair or equipping for a foreign vessel are given the status and priority of a maritime lien. Marine Liability Act. Foreign maritime liens. Liens that arise outside of Canada and have a status equivalent to a maritime lien under the foreign law applicable to the claim are recognized by the Canadian court as traditional maritime lien and have the priority of a traditional maritime lien. In other words, the law that determines the nature of the lien is the foreign law, but the law applies in the rank of the lien is Canadian law. This is different from the law that is applied elsewhere, such as the UK, where both of the nature of the lien and its priority are determined by the local law. So that's all the article. Bye bye and see you on my next video. Bye.